abbreviated agenda today. We have the following items that have been pulled from the agenda. Item 3, AB 355 by Assemblymember Garcia is pulled. Item 16, AJR 9 by Assemblymember Chang has been pulled. So if you are here for either of those items, unless you just want to enjoy our company, no reason to stick around. Those have been pulled. Additionally, we have 8 items that are on the consent calendar. They are items 2, 5, 6, 7, 8, 9, 13, and 15. Again, 2, 5, 6, 7, 8, 9, 13, and 15. We need to establish quorum. Yes. Hold that man down. Okay. So again, if you are here in any of those measures, they are part of the consent calendar. And with that, I'm going to ask our secretary to please establish a quorum and call the roll.
Jackson?
Here.
Jackson here. Morlock? Morlock here. Anderson? Hertzberg? Hertzberg here. Leno? Monning? Wajkowski? Wajkowski here.
All right, we have established a quorum, and Senator Hertzberg moves the consent calendar. Please call the roll.
Jackson?
On the consent calendar. Jackson, aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Wajkowski? Wajkowski, aye. 4-0.
4-0. We will leave that on call, and we will start now with Assemblymember Stone. This is file item 1, AB 87, and the way we are going to do this, we don't have any real headbangers today. Most of these bills are pretty well settled and have the support of a sufficient number of legislators, I believe. So we're going to keep it short and simple. 2 minutes, 2 people on each side. We'll ask questions at that point and then take the vote. So Assemblymember Stone, thank you very much. And if you'd like to proceed.
Thank you, Madam Chair and Senators. AB 87, my first of 2 bills before you today. And when there was legislation last year looking at peremptory challenges, and some of the judges came in and arguing for that bill. This is not that bill, but arguing for that bill said sometimes peremptory challenges get used against transgender part of our community. And I thought, well, without respect to changing the number of peremptory challenges, I thought we could fix the issue of discrimination against any part of our community. That's what this bill is. It is about keeping the foundation of our justice system without discrimination, and that's what our bill does today. It prohibits peremptory challenges made on the assumption of any bias existing due to a person's gender identity, gender expression, ethnicity, age, genetic information, and disability. It aligns peremptory challenge law with many other laws in the state of California, and I ask for your aye votes.
Thank you very much. Any witnesses in support?
Good afternoon, Madam Chair and members. Kevin Baker from the American Civil Liberties Union. We believe that the bill provides helpful guidance to the courts and the parties. Thank you. Thank
you. Any witnesses, further witnesses in support?
Good afternoon, Madam Chair and members. Joe Michael for Equality California. We are proud to sponsor this bill, and we respectfully urge your aye vote. Thank you.
Thank you very much. Other witnesses in support, name and affiliation. Any witnesses in opposition? Seeing none, any questions from members? Yes, Senator Morlock.
Thank you, Madam Chair. I was just, maybe you help me out, I'm not a lawyer, but how does a jury selection, how does genetic information come up? I just couldn't get an understanding of that. So,
well, in the transgender community, someone may express male, but yet genetically be female or vice versa. And what we don't want is for an individual to be challenged based on a presumption from one of the attorneys and introduce bias in that sense.
so it just has to do with gender then. Thank you. That helps. Thank you.
Well, actually, I don't think that is accurately or completely accurate. If you have some kind of a health condition, for example, that is genetically based, so you have a predisposition to a particular type of illness or disease, that would also be a potential consideration. I'm trying to think of something offhand that is genetically transmitted. Is that accurate, Assemblyman?
Well, yes, that is true. And in existing law, you will see that case. What I was trying to focus on here is the transgender community, the LGBTIQ community, the intersex, where they may be exhibiting something that in a case may or may not be relevant, but still find a basis for excluding them from jury service. And the same thing would be true for someone with some specific genetic disposition, may or may not be relevant in the trial, but yet would provide a basis for some kind of a bias or exclusion from jury service.
And since I've never been part of selecting a jury, how would you know that discrimination was in fact happening? Would it have to be really obvious, or?
Not necessarily done on a case-by-case basis. Sometimes it's a pattern of particular lawyers who are holding out individuals all the time, maybe always taking someone who is of color, someone who is transgender, maybe always excusing someone who is gay. It just depends on the circumstance. And what we're trying to do is close that gap to make it expressly illegal to preclude that kind of behavior.
So it could occur over a series of cases.
Could.
Okay, thank you.
Senator Hertzberg.
Just a technical question. Can you help me a little bit here? I have the bill, which is very short in duration, and I forget the Leg Council because that's not part of the legislation. It simply amends Section 231.5 of the Code of Civil Procedure and just says, a party shall not use a peremptory challenge to remove a prospective juror on the basis of an assumption that the prospective juror is biased merely because of a characteristic listed or defined in Section 11135 of Government Code or similar grounds, whatever similar grounds means. And then when you look at the analysis, it talks about 11135 of the Government Code. But I'm understanding how you make that, and that's all about prejudice, you know, sexual orientation and those types of things. So I don't understand how this deals with the issues you're talking about. I mean, basically all it says is that you can't use, for any of these discriminatory effects, whatever those things are, you can't use that as a basis for a preemptive challenge. So it applies to anything. You can say, you know, I'm not going to presumptive challenge because you're Jewish or because you're whatever, right? I mean, it's a broadly, as written, this is much different than just as it was described, no?
The existing law is, but the issue that came up last year, which is why in my introduction I prefaced it.
I couldn't understand.
Because judges were coming in saying that in an unrelated to this bill case, talking about the number of peremptory challenges that were available, we're saying, for example, they had seen examples where someone who was transgender might be discriminated against, and that was an argument for reducing the number of peremptory challenges. I thought that's an issue we can take care of by making it very clear that if you're transgender, whatever someone presents to the jury or to being a potentially qualified juror and presents in that case, whatever their circumstance is, should not lead to any bias or exclusion from being able to serve as a juror. And if that's proven over a course of pattern of practice, or that's obvious in that case, then that would give rise to
it's true.
claim of bias or discrimination.
I'm just language of the measure, and I'm just, like, I guess the questions I don't have before me. There's a quote in here, I missed it, this Government Code section. It should apply to everything, which is good. I like it. I'm not, I like the more expansive view. I think it's a good policy.
If you look at page 4 of the analysis, it does indicate on the top, under existing law, provides that a party may not use a peremptory on the basis of race, color, religion, sex, national origin, sexual orientation, or similar ground. That's already existing law.
Yeah, but it quotes section 231 of the Code of Civil Procedure, .5. This amends 231.5.
Right, it just adds those additional grounds that cannot be used to discriminate.
But it doesn't say, so is that in Government Code section 11135? Is that where it is?
Yes.
Yes.
Because it cross-references it, that's all. I'm trying to understand it. Because it doesn't say that in the bill.
Because that exists.
Yes, it's a.
Yeah, but existing law says that no person shall, on the basis of race, national origin, ethnic group identification, religion, age, sex, sexual orientation, color, genetic information, going back to the question, or disability, be unlawfully denied full and equal access to benefits, unlawful subject to discrimination, blah, 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 blah. That's the code section, 1135, 11135A. That's A. This is 1135. Then here's the
We are
other code
applying
section.
that code section to peremptory challenges.
I see. I see.
And
so
that's
that-
where I said, in existing law, there are protections, but not necessarily in the
clear that
case
apply.
of peremptory challenge. So we're making it very clear that we're just making it parallel with existing law, peremptory challenge law.
Okay. Any other questions? Yes, Senator Monning.
Apologize if this has been covered, but I appreciate your bringing this up, and I guess the question becomes, how do you prove when somebody uses the peremptory and there's clearly a discriminatory motive, or there's suspicion that it's a discriminatory motive? For example, African-American defendant, African-American prospective juror, the peremptory is used on the African-American prospective jurors, or more than one prospective African-American juror. How do you connect to prove that the intention was a discriminatory one?
It can be difficult to prove, and for example, if on a jury, a lawyer uses all of their peremptory challenges to remove someone from a class, all African Americans, all gays, or over a pattern of trials starts to exhibit that is where one would find evidence of the bias.
And so you could look to past exercise in other trials, not just in the limited window of today's trial.
Right, correct.
Thank you.
Can I just add
Senator
one
Hertzberg, yes.
thought to dovetail on that?
Through the chair.
Thank you. Thanks so much. Because it seems to me that what really is happening here is that the other party on the other side of the case will be the real the entity that will then push it, right? Because when you're doing your peremptory challenges, if someone's engaged in improper, challenges on their peremptories, the other side, the defense or the prosecution, whatever it is, sees the pattern and will then look to this law and ask the judge to make a ruling. It seems to me it's kind of almost self-enforcing. You know what I mean? That's how it's going to happen.
Right. At least it creates the tool.
It creates a tool. That's, it's smart. Yeah, they'll fight it out.
Okay. All righty. Any other questions? All right, Assembly Member, you can close.
I ask for your aye vote.
Very good. Please, we need a motion. Moved by Senator Monning. The motion is to pass to the Senate floor. Please call the members.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? No. Anderson, no. Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Aye. Monning, aye. Wachowski? 4-1.
4-1, that bill is on call. Thank you, Assembly Member Stone. And there is your second item.
The second item is a bill with respect to private transfer fees. It clarifies three things: the definition of a private transfer fee, the method of calculating that fee, if the fee is neither flat nor a percentage of sales.
Excuse me, this is file item 11, and it is
AB 807.
AB 807. Thank you.
And requires disclosures about the private transfer fee and how that must appear in a single document and not incorporated by reference. It's a bit of a cleanup matter. The existing law provides that when a transfer fee is imposed on real property on or after July 1st, 2008, the person or entity imposing the transfer fee must, as a condition of the payment of the fee, concurrently record against the property a separate document called the payment of transfer fee required. This bill is needed to ensure continued notification and disclosure of such fee to homeowners, because some private transfer fees are structured differently since the legislature enacted these requirements back in 2007. I have some witnesses in support, and I respectfully request your aye votes.
Thank you, Assemblymember Stone. Witnesses.
Rick Carlisle with the California Association of Realtors, sponsors of this measure. Quite simply, this measure will overturn the decision in the Marina case so that the information that has to be disclosed actually has to be recorded and can't be referenced by or incorporated by reference to some other document. Ask for your aye vote. If you have any questions, more than happy to answer them.
Thank you. Any other witnesses in support? Any witnesses in opposition? Okay. What is the purpose of these fees?
They're actually a revenue generator, and they arose because sometimes you'd have a developer that was going to be putting in a number of homes, like the Sierra Club would show up and say, okay, well, you're threatening the three-legged red-eyed frog, and so they would institute these things to provide environmental mitigation for that three-eyed red-eyed frog, or three-legged red-eyed frog, and the builders would do it because they didn't have to pay it. It was the homeowners that were buying the homes. Realtors actually tried to prohibit these things and ban them entirely, and we were not successful in that effort, unfortunately.
So at the initial point when there was discovered you had the red-legged frog, I think is what it is, not three-legged, but red-legged, or the, could be, I could have that wrong. A few of them showed up very interestingly in an effort by a developer in my community, and suddenly they were endangered, so the development never happened. We're wondering where those things had come from. But that being said, what is, the purpose of this was originally for the developer or to be able to mitigate the environmental concerns, but these things continue, do they not?
It can be used for any number of things, including just simply a revenue stream for the original developer, which is why what this bill does is clarifies what they are, how they're calculated, and ensures that they will be adequately disclosed so that any subsequent purchaser knows exactly what they're buying into.
So the developer is able to continue making money with each sale and can do whatever they want with the money.
Potentially.
Potentially.
It all depends on how they're written, which is why we'd like them written clearly, so any purchaser, subsequent purchaser knows exactly what can happen. And for example, they could be set up from the developer that it's not paid by the initial purchaser, but by every subsequent purchaser, any number of ways that can happen. That's why we're looking for clarity.
Is there any justification for these fees? I mean, is the dollar amount that's sought relevant to anything at all?
They're sucking equity out of the home. If you have one, for example, on your home, let's say it's the Hannah Beth Jackson Tahiti Vacation Fund, I'm going to pay you less when I go to buy your home because I know when I go to sell my home, my buyer is going to pay me less. So they're just, as I said, we tried to ban them. We're not successful in that effort. They have been severely restricted by FHFA. They begin to almost look like HOA fees. But again, that's only for mortgages that are funded by Fannie or Freddie.
So if
and in their best instance, they can be for environmental remediation, they can be for infrastructure installation, and then it spreads out the cost of that over the homes in a development.
I guess what puzzles me is why, if I'm the fourth or fifth homeowner of a house, am I still paying the developer for something that happened 30, 40, 50 years ago?
That's a good question, and these fees are on the books, they are allowable. That's why we're trying to make sure that they're very apparent and they're not referenced, they're not included by some reference to a document, so that when someone buys a property, they know exactly what fees are there or not. They can then, as part of their negotiation, adjust the purchase price based on the fact that those fees are continuing with the property.
But the developer is not a party to the contract.
That's true.
But it's a lien.
But they record it.
Land.
Yeah, it's something that is recorded with the land, so it goes to every subsequent purchaser.
So is there anything that we can do so people know that there is this cost that's being incurred?
That's what the bill's for.
But does it specify exactly how much of the purchase price and who it's going to, and ostensibly for what purpose?
It's not necessarily related to the purchase price, but it makes it very clear for a subsequent purchaser that there is a private transfer fee that is on the property. So when you buy this property, you will be subject to this fee. That's the point of the bill. So that every subsequent purchaser is now on notice. They may not like it, they may not care, but it's not going to be something that will pop up later on after the transaction that all of a sudden it now applies to them. They need to start paying it. We want them to know about it if it exists as that subsequent purchaser is acquiring the property.
Okay, Senator, thank you. Senator Hertzberg.
No, I mean, what happened was when it became kind of a financing gimmick that was used in the industry, where you came in, instead of paying $500,000 for the house and the financing costs were borne by the buyer, you buy the house for $250,000 and there's a revenue stream that's assigned to the land, and that revenue stream often was sold by the developer to third parties who then the developer got their money, and so they could actually get in the market cheaper. But then the problem was, as was noted by the author, the property was encumbered by this revenue stream, and I think what they're trying to say here is that, you know, whether this was a good idea or not, we're now stuck with it, and the bottom line is let's just make sure there's full and clear disclosure that we all know that we're paying for the chairwoman's Tahiti fund.
It's nice to know. I appreciate it.
Just one other question, Mr. Carlisle. What you referred to some case. What is this case and what did it hold?
The Marina case held that you could record a document that referenced another document that had the information that the chair mentioned that should be disclosed, the amount of the fee.
Why, if that was the case, you're just codifying the case authority?
So we're overturning the finding.
Overturning it.
Right. So that the actual document with the information has to be recorded.
Has to be recorded.
Rather than to
As opposed to
refer,
recording a
to make
document that
reference,
references
yeah.
another document.
Yeah. All right, Senator Morlock. And before we go forward, there are some amendments, and I understand you're also taking the amendments as authors' amendments?
Yes.
Yes.
Okay, very good. So, Senator Morlock.
This appears to be retroactive, so I'm just curious, how do you do something retroactive when it comes to disclosure?
We're just trying to make sure that even transactions that happened prior to when this bill becomes law will need to be recorded properly.
So who is responsible for doing that?
The lien holder would need to make sure that their recordation is appropriate.
So they're going to have some work if it hasn't been done. And do we have an analysis of how much that'll cost or how many parties are impacted by that?
No.
Yeah, for the clerk recorder, but if someone has to pay for it, I just wonder what we're talking about.
Do you have any response as to who is
There's no
expected
compendium
to?
of all of these private transfer fees that are out there. But with regard to your question, and that was the amendment that the author just took, because I know what I was trying to do when I wrote that bill 7 years ago, and it was to require that one single document be recorded with that information on it. So as far as I'm concerned, the court got it wrong. So on the one hand, I want to say, this is declaratory of existing law. We really want it to be, but on the other hand, I need to overturn that decision. But at the point at which the Marina case was appealed to the Supreme Court and the Supreme Court denied cert, that then became the law. So we're kind of stuck in this weird way, and that's how come we have this sort of catch-up provision that the author just took.
Which is the amendment. Okay, very good. Any other questions? So in other words, no longer can you incorporate by reference. You have to have the information about just what you're paying a third party who has some kind of lien on the land from the original purchase. I think nice money if you can do it, but your bill will make it more public. Disclosure will be required, and then with the amendments, there will have to be that attempt to reconcile that in the existing documentation. Any other questions? All right, Assemblymember Stone, you may close.
I ask for your aye vote.
Very good. All right, this requires a motion. Do we have a motion? Moved by Senator Wojciechowski. It is due pass as amended to the Senate floor. Madam Secretary?
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, aye. Hertzberg? Leno? Monning? Monning, aye. Wojciechowski? Wojciechowski, aye.
5-0, we'll leave that on call. Thank you very much, Mr. Stone. Our next item is item 4, AB 365 by Assemblymember Cristina Garcia. Good afternoon.
Afternoon. You're welcome. Good afternoon. During my trip to Mexico, it was brought to my attention that in 2011, an estimated 5,100 children were in foster care while their parents were being detained or deported due to the parents' immigration status. It's projected that without major change, this number will rise to 15,000 children nationwide by next year. Teleconferencing and other electronic means are permitted during child custody proceedings when a party is in another state or a party's military deployment impacts their ability to appear in person. However, it's not currently done across the state for detained or deported parents. While some counties provide these services, in others, the detained or deported parent does not have the viable way to be present at court. This increases the chance that the parent will lose custody of their child. What is missing is equal access across the state to testimony by electronic means for parents who cannot physically be present in court due to being detained or reported. AB 365 would require the courts to allow any detained or deported parent to present testimony and evidence by electronic means in court-ordered child custody mediations upon request. Electronic means includes telephone, video conferencing, or the internet, provided that their use is consistent with the due process right of all parties. With me testifies Kimberly Rosenberg with SEIU.
Thank you very much.
Hi, I'm here on behalf of SEIU State Council. We represent 700,000 members in all 58 counties. We're particularly interested in this bill and in support as we represent not only court employees, but we stand strong with immigrant families. This bill is a common sense bridging the gap for all families. Many of the parents are there beyond means of their control, and we think there's already existing technology. It's already provided to many members, as mentioned, for families that are overseas. So we think this is just a good parity issue.
Thank you. Any other witnesses in support? Any witnesses in opposition? You're in support? I'm sorry, I moved a little too quickly. Please.
My name is Raji Prasad. I'm from the National Association of Social Workers California chapter, and we're also in support.
Thank you. Any other witnesses in support? Okay. Any witnesses in opposition? Seeing none, any questions from the members here of the author? All right. Senator Monning.
Comment more than a question, but I thank the author for focusing in on this. We talk a lot about family values and protecting the integrity of a family, and there can be no connection more important than a hearing that's going to determine the custody of a child and not allowing a parent or parents to be party to that and participate so that a court can make an informed decision and hopefully work towards the reunification of the family. So thank you for bringing this forward. Madam Chair, I'm glad to move the bill at the appropriate time.
Thank you. And I would also like to add, I hope that we have more opportunities to use the electronic resources available to make sure that people do have their opportunity, even if they are distances away or their circumstances don't allow it, to be able to access the court. So I hope that the funding is there, and certainly with legislation like this, we'll see more and more opportunity arise. So thank you as well. I want to join in that. Any other comments? Would you like to close?
I ask for your aye vote.
Thank you very much. All right. We have a motion by Senator Monning. It's due pass to Senate Appropriations. Madam Secretary.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, aye. Hertzberg?
Aye.
Hertzberg, aye. Leno? Monning? Monning, aye. Wachowski? Wachowski, aye.
6-0. We'll leave that on call for the absent members.